We are live.
We are back in Senate Judiciary. It's April 29th, and we are going back to H 772, and we have Ledge Council here. The floor is all yours.
Morning, for the record, Cameron Wood, Office of Legislative Counsel. So you have a draft 2.1 of a strike all amendment to 772 that has some alterations based on the testimony you all received last week. And I'll walk through those here with you. Want to share my screen? Okay. The first change is going to be on page 2, where two things. This is in the definition section. I removed the definition of what was actual or imminent threat because it was no longer relevant based on some of the requested changes from the Network Against Domestic Violence related to bifurcating the rental agreement. So based on some of their requested changes that they had provided to you all in writing, I've incorporated some of those. That definition was no longer necessary. It wasn't in the bill any longer. And then I referenced to the definition of protected tenant, which is defined in a separate subchapter under the residential rental agreement chapter. So we're simply referencing to where that definition already exists. It's a victim of domestic abuse, sexual assault, or stalking. Is essentially is what it's defined as later on. And that's going to be relevant when I get to the changes for the bifurcation of the rental agreement piece. The next change is going to be all the way down on page 7, related to terminating the rental agreement. And so if you all remember, we were having a discussion last time. This is under the B2. So terminating a rental agreement when there is, as the language is written here in this amendment, criminal activity, damage to the dwelling unit or premise, or acts of violence, any of which is an ongoing threat to the safety of other residents. So you have that reference to ongoing. The previous version, it said ongoing or repeated. So we've removed the word repeated. But at this point, it would have to be activity that meets one of those criteria. It has to be criminal, damage to the dwelling unit and the premises, or an act of violence. And it would have to be an ongoing threat to the safety of other residents. So you would have to demonstrate it could be one act, but the landlord would have to make a case that there's still an ongoing threat based on whatever that was.
And then the ejectment process also requires that the person's continued occupation.
Yes, sir.
An ongoing threat.
Yeah, I want to get to that language specifically. Yes, sir, you are. So this is going to be on page 17. When you look at the language that is in the proposal for this expedited hearing section, it says that the plaintiff is entitled to immediate possession on the grounds that the defendant's continued occupation of the land or tenements is threatening the safety or other residents. So their continued occupation of that unit is a threat to others.
Mr. Chair.
Yep.
I continue to have a little bit of a problem here because it seems like we're mixing two things: damage to the dwelling unit, and then it has to be connected to safety. Originally health or safety, but now safety. And I understand that there could be an example. For instance, I was just suggested breaking a lock would affect safety as well as the unit. But I just feel like the impulse is to draw in financial damage to the unit in a paragraph that's mostly about criminal activity and acts of violence. So I guess I just keep stopping over damage to the dwelling unit because it seems like that's in a different category almost always. If you see what I mean, not ongoing threats to other people, but threats to the commercial health of the property, which seems like a different thing.
And I know
Maybe any other thoughts on that particular piece?
I apologize for being late. So are you against this? Senator Brooks?
I'm just saying, it's a paragraph talking about termination based on criminal activity, acts of violence, and then it has to be a threat to safety. Damage to the dwelling unit seems like a more, I don't know, a more commercial piece of this. And I don't know that I feel like there are going to be a lot of instances where damage to the dwelling unit would be an ongoing threat to the safety of the residents.
Well, it could be a situation where, you know, a secure door or busted in door that somebody has, or even, you know, something happens in an apartment and there's a plumbing issue and water goes all over the place. And then trickles down to the other units, or if there's even a gas line, something like that, you know, there could be a damage in many different ways. So that's the part you know, and it can be in connection with criminal or acts of violence.
And I guess that's my other thing, is I
It's
think
swept up.
what you were talking about is covered, in my way of thinking, by criminal activity or acts of violence. It's just that the violence is directed against the property, and that affects the safety. So, I don't know, I feel like damage to the dwelling unit gets you into the whole area of disputes with the landlord about did you damage the dwelling, did you give your security thoughts back, that kind of stuff. But then it has to be connected to the safety. So it just seems a little strange with that connection.
Did we move past the threatened, crossing out the threatened part? Because I remember we had a long discussion last time on does it threaten kind of mean it
Right.
can be ongoing, or because I think of it in a way is an ongoing threat. I think of it as a way if it's threatened behavior, and a tenant doesn't want to come forward if it's towards one another and you know, worry of retaliation from the other tenant. So if it's just that one time, but it really actually was built up over time,
Yeah,
but you don't want to come out and say it's building over time because of the retaliation.
yeah, I think that with how we're phrasing it now, an ongoing threat gets to the idea, you know, the hypothetical that was raised earlier, you know, the tenant stabs somebody, you have to wait for them to stab another person. But stab a person once,
I think you're
there's an ongoing threat.
Stabs.
You're also probably gonna be held without bail, but
It was probably an escalating pattern of behavior that led to that too, that would be able to prove that ongoing threat.
yeah. So I think the ongoing threat, I believe, it is meant to address that concern. And then there's also the second part with the ejectment process regarding the
Right.
the tenant's continued occupation. Yep, poses a threat. And I feel like it's gotta be relatively straightforward to argue that one tenant committed an aggravated assault or even a simple assault against another tenant. The victim tenant does not feel safe. They got a RFA, so on. There's an ongoing threat to the safety in that particular situation. That's my.
Yeah, grab up the second part.
Regarding the damage piece, I mean, I feel like if you are breaking blocks and smashing windows, it's gonna fall under criminal activity. If your plumbing is messed up or you're, you know, doing things that cause damage to the infrastructure, it's not necessarily criminal, but it's, I mean, unless you're doing it intentionally. Then if you're doing it intentionally, then it falls under the criminal activity. So I want to put a pin on the damage piece. Contemplate that a bit more.
Just on the criminal activity kind of definition, does there have to be like a charge with it or anything like that to make it criminal activity, or is it just
I think potentially be charged.
broader?
Yeah, I think it can be broader. That is my understanding. I'm happy to be corrected if I'm wrong, but I think if, if there are police reports, because a neighbor is calling the police multiple times for whatever reasons, or, if the landlord's complaining and they're affidavit to the court, they're describing what they believe is criminal activity, and they're supplementing that with police reports. That's like we get there. Obviously, if you get charged or convicted, then there's yeah, you have a spotter case there. But I think that if a landlord filed a complaint and all it says is, I think the tenant is dealing drugs, and that's all we have, and I don't see how you're gonna really have a case there.
Okay, so I know we got a plug here, B2, we can come back to it. The next few changes, starting on page 8, are to accomplish some requests that the Vermont network had, as I mentioned the last time they were here last week. So we have a little bit of cleanup on page 8 here. We've added in protected tenants, so it just mirrors and aligns with the language further on in the chapter. And then what we have here on the 5B line 8 is that they may request the bifurcation of the rental agreement. The previous versions of the bill had the landlord was required to bifurcate in the event that the tenant requested it. And we have a slight tweak here to say that they may bifurcate the agreement. And it's going to be relevant when we get to the appropriate new section, or into the scroll. This is all the way down to page 14. These are the next changes where you have this new section in law that A1 says a landlord may approve. It originally said shall authorize, and so I've changed that language slightly. May approve a protected tenant's written request to bifurcate a rental agreement in order to eject, remove, or terminate a rental agreement with an individual who is a tenant or lawful occupant that engages in abuse, sexual assault, or stalking against the protected tenant. So if there's a written request from the victim tenant, the landlord may bifurcate that agreement to then eject the abuser in that situation.
But if a court order, then they shall.
Yes, sir. We're getting to the sub 2 there. If the protected tenant, the victim, includes with that written request a copy of a court order that requires the perpetrator to leave the premises, then the landlord shall bifurcate the agreement at that point. One comment, and I was speaking with some individuals from the network earlier, I wasn't sure if the word perpetrator was the proper term here. So I was going to flag that for Michelle Childs and let her chime in and whether that needs to be altered too. I just want to make sure the phrasing of the individual is correct here.
Yeah, I think I made a note of that same language as a question mark. Right. My other copy.
So I have not yet sent that to Michelle because I just pulled this together. Was finalizing some language with the network this morning, so I will share that with her and get her feedback this afternoon. And then you have the sub 3 with
Yeah, I got a question here, Cameron. This is on line 4 when we mentioned protected. And I read this: a landlord shall not terminate a rental agreement of a tenant under this subsection because a tenant is a victim of incident domestic. Would that cover? Why is the protected in there? A tenant is a tenant. I mean, they're already protected.
So are you talking about on page 8?
Page 8.
Yes, sir. So originally I had it as just tenants. The issue is this language on page 8 is going in the residential rental agreement subchapter related to terminating rental agreements. Later on, there is a separate subchapter about victims of domestic violence and some rights that they have. They can request locks be changed, et cetera. There's some language that you all put in statute years back. It refers to protected tenant. And so the request here, as part of the network's language change, was to true that up. So you're referring to it as a protected tenant in both the section above here on page 8, and then later on protected tenant on page 14, where the new section is going to go. So it's really more of synchronizing those two.
So, but I don't, whatever, I don't think it's needed, but a tenant is a tenant, but on line 5, it says, B, because the tenant is the victim, they're no longer the protected tenant, that's tenant now.
I agree with you. I think if you had it just referring to a tenant in 5A and 5B, it would be just fine.
It would be just fine.
You wouldn't have to refer to protected here because, technically, when you're looking at 5B, the way, and let me get back to the page. So, it says a protected tenant who is the victim of domestic abuse, sexual assault, or stalking by another tenant. Well, the definition of protected tenant is defined as a victim of one of those things. So it gets a little squishy with the language. I don't think if it just referred to tenant, I think it would be okay. Legally, the language would be fine. If you want to use the term protected tenant, so it matches what you have down below in the section that's being added to allow the bifurcation. So it's not tenant in one instance and protected tenant in another. If you want it to be synchronized, go with protected tenant. Legally, it's not, there's no consequence if you remove the word protected on this page. Okay.
Yeah, I would like to keep things, that does help. I like to keep things consistent and clear throughout. So is the reason that I think you mentioned this already, but the reason we have a protected tenant is because it was established elsewhere in statute a while ago.
Yes, sir. Okay. And I could pull that up if that's,
If you don't mind. Helpful. I was looking for it in this bill, but it looks like
so. In the residential rental agreement chapter 137, we have different subchapters here. So the termination language is going to be here, the termination of tenancy. So it's up here in subchapter 2, which kind of provides all of the requirements for residential rental agreements. And this is going to be slightly embarrassing, but subchapter 4 is currently labeled campgrounds. It's a statutory revision error that needs to be fixed. It technically should be, I don't remember the exact language and I didn't bring it with me, but the subchapter should refer to, circumstances where there's an instance of domestic violence, a victim of domestic violence, etc. That's what those sections are about. And so, for example, 4472 allows a protected tenant the right to terminate an agreement if they're a protected tenant because they've been a victim of domestic abuse, sexual assault, or stalking.
right one. Sorry about it.
No, I was just gonna say, would it be a good place to put in this bill
It's
to change that?
It's been changed previously, so it's just an error that we need to fix.
Oh, okay.
We can put it back in the bill, but it's just, every summer we go through and fix errors that are in your statutes. This is one of them that will be fixed this summer. And so, so it shouldn't say campground. It's supposed to say something else. Okay, so they can terminate, the protected tenant can terminate the rental agreement. The protected tenant can request locks be changed, and then there's a section regarding confidential of, the information for the protected tenant, et cetera. So this new section about bifurcating the rental agreement, allowing the individual to have the written request to bifurcate, and then requiring the landlord to bifurcate if there's a court order. I felt that it was best to put that new section here. So it is in in the same sequence as the other protections that you put in statute for victims of domestic abuse, sexual assault, or stalking related to rental agreements. So
Can
in
you just pull up
this,
the definitions section real quick while you're
absolutely.
going through?
So down here is referred to protected tenants. And obviously it is a victim of abuse, sexual assault, or stalking, or a parent, foster parent, legal guardian, caretaker with partial physical custody of the victim. And so in adding this new section, forgive me, I'm gonna switch gears and I'm gonna go down to, I think we're on page 14. So in adding this new section that authorizes the protected tenant to submit the written request, I need to use the term protected tenant because that's how it's defined in that subchapter.
Is there a conflict when we're saying on page 2 that a protected tenant has the same meaning as in section 4471, but and 4471 references sexual assault and stalking primarily, whereas in here we're referring to a protected tenant who is the victim of domestic abuse, sexual assault, or stalking. Is there any conflict or confusion when we add domestic abuse when it's not? Oh wait, it says a victim of abuse.
It's abuse and the references are the same. So you can see domestic abuse here is 15 BSA 11011, and then here abuse is 15 BSA 1101. So the cross references are correct and would match.
Okay.
And so the question is really this. In the termination section, subchapter 2, this doesn't have to say protected tenant. It could say tenant. You can have it as protected tenant if you wanted to synchronize specifically with the words with this new section. Again, it's more of probably a stylistic policy choice for you all as opposed to a legal issue.
What stylistic option?
So I'm just wondering, and looking at this, so does a protected tenant have more rights than say a tenant has in this particular situation?
No, sir.
Say my neighbor say I got punched by my neighbor. I'm not a victim of, because I've been assaulted or whatever else, so can I do the same things that protected tenant?
No, sir.
I can't.
No, sir.
Don't seem fair enough.
Well, I think if you're,
pay your rent.
are you living?
Oh, you're not living.
Yeah.
This
is for if you're-
specifically if you're living with the person, that allows one person to be evicted while protecting the other person.
Yes.
If you're living with somebody, you don't necessarily have to be in a relationship with them. Where if you get into a fight, it's still considered a domestic assault.
So my understanding is there's a few things here. If you recall, as the bill came over from the House, and you look at the B2 language, the language was expanded to say any activity which could be a threat to the health or safety of others. So it was no longer limited to criminal, illegal, or acts of violence. It was any activity which could be threatening to the health and safety of other people. And my understanding is the concern that was coming from the network was kind of twofold. First off, primarily, you have a situation where people live together, and if one person is the victim, then allowing the bifurcation of the rental agreement and the ejectment of the other tenant. But there's also a concern that was being raised about some sort of action from a landlord to eject someone who is the victim of a sexual assault, stalking, or domestic violence situation by arguing that there's activity going on that is threatening other people. You know, you are dating someone and you are the victim of a domestic abuse situation, and because you're dating that individual, it's threatening other people. It's threatening their health or safety because this person, you know, you're seeing that you're the victim of is violent. And so we're going to eject you under that section. And so that's where we came up initially with this protection here. So not only is it a protection in the later section, which says that you can bifurcate the rental agreement, But it's also protection to say, if you're the victim of some sort of domestic abuse, sexual assault, violent activity against you, you're the victim, the landlord can't eject you from the rental agreement. Now, one could argue that's already covered under your Unfair Housing Act prohibitions. You can't discriminate against people because they're the victim of domestic abuse, sexual assault, or stalking when it relates to housing. But just to make sure that the law was clear, want to protect individuals who are victims of these circumstances, we added that section. So ultimately, I do think it is okay to go back to what it was and just have this refer to tenant here. And then later on, it would refer to protected tenant to be consistent with the language that's in that subchapter. Because in that subchapter, again, you have a definition of protected tenant and it's used throughout all of the sections in this subchapter 4. And so if we're going to add that new section to allow the bifurcation of a rental agreement in that subchapter, it would be appropriate to be consistent with using protected tenant there. But when you're in the termination section here under 5A and B, there's nothing wrong with just using the word tenant instead of protected tenant.
I'm fine with that. If it makes no impact and it is the same thing. I mean, does anybody feel one way or the other?
I go along with it. The covered protected tenant is covered in the King's Government. So I'll talk about it.
Is there more clarity about what we're talking about if we use the same language as in other places in statute?
It's possible that, using it here does kind of further signal the link up between the section below and the subchapter. It's using the exact same terminology and I don't mean to speak for the network, but I assume that's why they were advocating for it to be used up here as well, is because that's the terminology that's used below.
Mm-hmm. I mean, I appreciate that functionally it has the same function, but I think anywhere where we can really be clear what we mean and what we're talking about, it just makes sense.
Maybe. But I don't want to. Yeah.
You're at 10:30. I'll continue to noodle this. I'll come back next time we
revisit this.
There's one other change. So again, we talked about the bifurcation of the rental agreement. My apologies for the scroll here. There's one other change at the bottom where there was a request to, as part of the discussion that with some of the advocates, there was a question about whether or not to study the implementation of a dedicated housing docket. That, has been one of the concerns, that has been raised in the committee throughout the testimony on this bill, is not having a dedicated, housing docket here in the state of Vermont, as some other states have. And so I drafted up this study here. A few things. It's on or before January 31 of 2027. I don't know if that would be enough time to properly study this change. So that may be something you want to get feedback from the judiciary about whether or not there's a feasible time frame to look into this.
1 second before I forget, Henry, could you reach out to Terry and ask her that question regarding January 31st, 2027? Please. Okay, thanks.
So it has January 31st, the court administrator shall submit to the General Assembly a report on the feasibility of implementing a dedicated docket in Vermont for handling all matters governing residential rental agreements and ejectment actions. The report shall include an examination of financial costs, workforce impact, including number of judges and staff necessary to resolve ejectment action statewide. Here is another piece. I put in here 90 days, which just meant as a placeholder. You all remember the testimony currently. The Judiciary has said their goal is to resolve cases within 180 days. I went with 90 just because that was what was referenced in the new subchapter earlier that's been removed, so just please understand that was a placeholder. Policy decision for you all of what you would expect the proper time frame to be if there was a dedicated housing docket. Workforce impact of other court staff. Whether current state facilities have the capacity to support a dedicated housing court, and it could be a dedicated housing docket statewide, whether new or expanded facilities would be required, whether there are technical capabilities within the judiciary to handle implementation of a centralized housing court, and any other matters deemed relevant to the issue of implementing a statewide housing court. I based this off language that had been used previously to study, I can't remember what was on the document, I think something related to a dedicated drug court docket, I believe. But so it's been used similar. But obviously for you all, if you wanted this section to move forward, you wanted this report, I would want to make sure the language reflects the information that you would be seeking from the court in order to move forward with a dedicated docket.
I think keeping the 90 days is fine. And I'm sure they would come back and say, you can do 120 days, but I doubt if we put 120 days, they'll come back and say, actually, you can do it in 90 days. So we'll give them that leeway. Senator Phillips.
As you view it, the workforce impact, does that include whether or not more workforce would be necessary?
I was thinking about it twofold, whether or not the judiciary would need more judges and more staff. But I also included the workforce impact on other court staff. My thought was, if you're creating a dedicated docket, you may need more staff to handle that, but how does that impact the workloads of the other staff that exist? Just what are those impacts going to be? Either more staff, or does that mean some other staff potentially, I hate to say it, but lose their job or need to be dedicated to other work? I mean, if you're implementing a dedicated docket to this, presumably you need staff to then manage that. And then how does that workload impact other people that are already employed?
Yeah, I just want to make sure that the term, the way we frame it gets at both of those things, because I think sometimes as I read just sort of plain language, the workforce impact, I could imagine them coming back and saying, we can't do it. We don't have the workforce impact would be too great, as opposed to well, we could do it, but we need,
Right.
A new judge, 3 new states,
And I think that's why I tried to tie it together to say, including the number of judges and staff necessary to resolve those actions within 90 days. So you're kind of tying that to say, if 90 days is going to be our barometer, and we want all of these cases decided, what is the staff take to get there? But I finished penciling and massaging this out this morning. I obviously haven't shared it with anyone. You're all seeing it for the first time, so you may want feedback from the court system who would be charged at this point with doing a report.
Yes. So we have to move on to Eric here. Do you have availability tomorrow and Friday?
Yes, sir. Tomorrow I am pretty open at this point in the morning. I was supposed to be in Senate Economic Development for a small piece, but I did not testify, so I can follow up with them. Friday morning, I will allow you and the chair of that committee to resolve where you would like to go.
Okay. So we'll come back to this hopefully on both days. And yeah, we'll keep working on it.
Sound good? And I will keep just on the protected tenant thing. I'll follow up with the network.
All right, that's it.
Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here to everybody do a quick look at the possible amendment to, House Bill 642, which is the youthful offender proceeding bill.
And we just have copies.
No, we're gonna, everything passed on a proposed amendment that shows a couple of changes. I'll say upfront that changes are very minor. In fact, there's only really one substantive change, one technical one substantive one. Both highlighted, so I'll explain what those two things are. First one, purely technical, page 1, just a cross-reference that was wrong. So that's correcting the cross-reference. And remember, this is the idea of the youthful offender proceeding, which right now there's two types of hearings that takes place. The first one is called the youthful offender consideration hearing. And it's at the consideration hearing that the court has to decide whether or not this youth is appropriate for youthful offender status. They have to consider things like, nature of the offense, whether there are services available in DCF and DCC, whether or not public safety will be protected, whether the youth is amenable to treatment, that sort of thing. That's at the initial decision point that the court has to make. Does this young person a good fit for youthful offender status in the first place? If the court says yes, then it has a second hearing, disposition. It's at the disposition hearing that's sort of, I think Senator Hofsky mentioned this before, it's sort of analogous in a way to sense. But that's when the court's deciding, well, what's the best case plan? I have to look at it. It has to approve a case plan, has to approve conditions of juvenile probation. So that all happens at that second hearing, disposition hearing. As the bill came over from the House, it provided, and now we're looking at pages 4 and 5. As the bill came over from the House, the change to this portion of the bill, because under current law, the victim is permitted to appear and make a statement at that second hearing, the disposition. The House passed version permitted the victim to appear and make a statement and be called upon at that first hearing, the consideration. So I think the committee's decision last time you looked at the bill was, we're fine with the victim being permitted to appear at that first hearing, the youthful offender consideration hearing. Not comfortable with having the victim at that hearing be called upon to make a statement about whether or not youthful offender status is appropriate. And I think the committee's view of that decision is really one that's for the court and based on the criteria. So that's where
Real quick, just for the committee, I just forwarded you all an email from Jen Pullman, who was following along, and just to summarize, she was supportive of this change of having the victim there, but their opinion on the appropriateness is not entirely in their realm. I mean, I just sent you the emails, we can look at it, but I'm inferring the general support with changes here that are being proposed. So, thank you.
Yeah,
I just wanted to start interrupting.
Yeah, no, not at all. Very relevant. So yes, that's exactly what this committee's proposed amendment would do. If you look at page 4, lines 11 and 12. So it leaves in the additional language underlined there on lines 11 and 12. So allowing the victim to attend the hearing on the motion considering equal offense. So they are required the court's required to permit them to be there. But further down there, they wouldn't be expressing their views on the appropriateness of youthful offender status. That would be the court's decision. And that's the same thing that's done on page 5. Those changes you see here, it's the same thing. Their views on the appropriateness of youthful offender status would be left up to the court rather than the victim expressing their opinion on that. And that's really it. Other than that, it just keeps the provisions that were in the House bill regarding revocation of youthful offender status. That while a motion like that is pending, then the court's jurisdiction can be extended so that they can retain jurisdiction over the case while they're still deciding what to do if there's been a revocation motion. Similarly, the piece about if the youth doesn't show up at a revocation hearing, then the court may use existing law to transport the youth to the court for purposes of responding to the original revocation proceeding. keeps those provisions, and the only change is the one that we just went with.
Committee, any questions? Or comments, recommendations, or anything along those lines? Okay. So we're gonna hold off on voting. The only other bill at this moment that we're gonna be voting on is the miscellaneous bill. We're gonna be waiting to get at least some other bills back from the House. We've sent them quite a lot, and I haven't seen even, one of my 3 top priorities come back yet. So we're gonna hold off on voting for this one. The only other bill that has to pass is the miscellaneous bill. I do want to get this bill out as well as the landlord tenant bill. But just wanted to share with the committee what my thoughts are. Sorry. So we'll put this in the pile of things that are ready to be voted on, and we will keep it there for the time being. So thank you, Eric.
Yeah, sure, sounds good.